All right, welcome everyone. My name is Andy Nevis. I'm president of the Taxpayers Association of El Dorado County, and doing a quick video today to give you some information about Proposition 19. As you may recall from your ballot, Proposition 19 makes a lot of changes to property taxes in California, specifically for inherited properties. So we're going to be talking today with El Dorado County Assessor Karl Weiland about Prop 19. First, just a little bit of background. As you may know, in 1978, voters passed Proposition 13 in reaction to skyrocketing property tax values. One of the features of Prop 13 was that every change in ownership required the property be reassessed at fair market value. Post-passage experience led to the conclusion that not all changes in ownership should be reappraised and reassessed. In 1984, voters passed Proposition 3, which provided that property owners who lost property through eminent domain actions by the government could transfer their assessed value to a replacement home. Not only did this fix the inequity for this issue, it also introduced the idea of portability as property owners watch their property taxes stay relatively low compared to their neighbors moving in. Voters approved transferring base year values to replacement residences when downsizing, transfers in disasters and when disabled, transferring to children and in some cases grandchildren, etc. Proposition 19 reset most of the rules for those transfers. So with that, we'll welcome in Assessor Weiland. Assessor, Prop 19 changed the ability of California property owners to transfer those base year values. What changes did the voters enact specifically with their approval on November 3rd?
Well, thank you, Andy. It's a pleasure to be here, and I appreciate the opportunity to share some of the information and provide an explanation of how Prop 19 changes those base year transfer rules. Under the prior initiative, property owners could transfer the assessed value of their home to a replacement property within the same county under what was known as Prop 60, or to a different county if the county had adopted an ordinance accepting the transfer. That was Prop 90. There were also provisions that allowed transfers in a declared disaster, or if someone became disabled, couldn't live in a two-story house, had to move to a one-story house. But there were some restrictions on it. There was, first off, it only applied inside the county unless a county had accepted transfers. And there was a value test that said the fair market value of the replacement had to be equal to or less than the fair market value of the original residence. All that changed under Prop 19 in very specific ways. First off, there's a rule that one of the property owners has to be over 55. That didn't change. The sale of the original residence and the purchase of the replacement residence has to occur within a 2-year time frame. That didn't change. But what did change is that you can now transfer your property to any other county in the state. There is no longer a requirement that the county allow you. And you can also buy a house worth more than your original residence and still transfer the base year value to that more expensive replacement residence. But it will that will cause an adjustment to your transferred base year value. So that was one big change that Prop 19 brought, was opening up the ability to transfer a base year value to a replacement residence for a property owner. And now under the new rules, you can actually transfer that base year value 3 times. The other big change that Prop 19 brought was the ability for parents to transfer the value of a principal residence to their children. Under the prior Prop 58 rules, parents could transfer a principal residence plus $1 million of other property from the parents to the children without any other requirements. Prop 19 has now imposed some restrictions on that. The first one is it is limited to the transfer of a principal residence. You can no longer transfer other property. So they narrowed that down. You have to transfer only the value of a principal residence. And they've added a requirement that it was always the principal residence of the transferor or the parents. Now it's required that the transferee or the children also occupy that property as a principal residence. So that was a significant change. For estate planning purposes, that alone will be significantly impactful. And the other, there's a cap on the benefit that the transferee can have. Essentially, if the fair market value of the residence is more than $1 million plus the assessed value of the property, the transfer base year value is limited to $1 million exclusion. And so that's another significant impact on that. There is a provision where the same rules apply to transfer from grandparents to grandchildren in cases where both of the parents are deceased. In addition to that, Prop 19 brings two different implementation dates. The implementation date for the base year transfer of a principal residence becomes effective on April 1st, 2021. That's roughly 3.5 months from now. However, the parent to child transfer restrictions and the changes, those become effective on February 16th of 2021. That's a lot closer. And so both of those provisions, those are the most significant provisions of Prop 19. Certainly, there are some unanswered questions, and the legislature is working on those. I think
I was muted there, but I just wanted to emphasize there, Karl, what kind of the takeaway from what you just said, which is that if people have homes that they're intending to transfer to their children, they should probably, ideally, they should be trying to get those taken care of before February, if they're hoping to take advantage of this benefit, or if somebody's already living in a property that's still the name of their parent.
Yes.
Yeah. So how did the base year? Go ahead.
No. Ask the question.
All right. I was just going to ask, how do the base year transfers operate under the new rules?
So under the new rules, a property owner can transfer a base year value to a replacement resident if the fair market value of the original residence is less than the fair market value of the replacement residence. Then it's the base year value that will become the assessed value of the replacement residence. So as an example, let's say you own a house that has a fair market value of $750,000, and you've owned it for a long, long time, and you're assessed at $300,000. And you sell that, you find a replacement residence for $500,000, and you purchase it. The assessor would look at the application and would assess your $500,000 house at the old assessed value of $300,000. That $200,000 difference is roughly $2,000 savings in property taxes every year. Let's take that example. You have a house that's worth $750,000 and you buy a house that's worth $1 million. In that case, you're buying up, and that $300,000 assessed value will be increased by the difference in the fair market value between the original and the replacement. I mean, $300,000 assessed value, the difference between the original residence value of 750 and the replacement residence value of $1 million is $250,000. Your new assessed value on your $1 million home would be $550,000. Again, a substantial savings.
All right. And I think we already touched on this a little bit, but I think it's really important to emphasize, how do the parent-child and grandparent-grandchild transfers work under these new rules?
Well, under the new rules, the ability to transfer is limited to a principal residence. It must be the principal residence of the transferor, the parents, and it must also become the principal residence of the transferee, the children. So in order to qualify, that residence would then would have to have a homeowner's exemption or a disabled vet exemption filed by the transferee and qualify as the principal residence of the transferee. That's the first significant way in which it changes. There's no more ability to transfer property outside of the principal residence. That $1 million in other property is gone after February 15th. The second thing that happens is there's a somewhat complicated formula for determining what the assessed value is going to be, but in essence, it boils down to there's a maximum $1 million exclusion on the fair market value of the property. If you own a property that's worth $2 million and you're assessed at $200,000, then you would be assessed at $1 million for that transferred base year value. Instead of just being able to transfer that $200,000 assessed, it gets adjusted. It's a little bit of a complicated formula, but that's our understanding of how the rules are. I think we've attached a link in this video to a letter to assessors from the State Board of Equalization that kind of walks through those calculations.
Yeah, and we're going to put that in the comments for the Facebook video, or if you're watching on YouTube, it'll be in the description. What other changes are there in Prop 19, and are there areas where there's still some dispute and discussion among experts about how this is all going to apply?
Yes, there are several areas that are still under discussion and haven't been resolved. One of the largest points of lack of understanding, for a better way, is there isn't a clear definition of the timelines involved with the implementation for the base year transfer. So if someone purchases or sells their original residence prior to April 1st and purchases the replacement after April 1st, most of us believe that qualifies. What happens if you purchase your replacement prior to April 1st, but don't sell the original residence until after April 1st is up in the air. I know that I've discussed this with our legal counsel. Both of us are pretty well convinced that as long as one of those transactions occurs after April 1st, we will qualify the residents for the base year transfer. There are questions regarding it. There are other questions regarding the definition of a family home for transfer from parents to children. The Prop 19 speaks of a family home also includes a family farm. There's some questions about what qualifies as a family farm, because a lot of these appraisal units that are family farms involve several parcels, one of which may have the principal residence on it. Another may have a commercial piece of property where you've got the winery or the retail operation located. And there's uncertainty as to, are we talking about the appraisal unit of the family farm, or are we strictly limited to the parcel that contains the principal residence? There's a lot of vagueness in the language of the ballot measure that leaves those questions unanswered.
All right. And last question, Karl. If people have questions about this, this is all very complex. And as you said, even there's questions even that the experts don't know the answers to quite yet. Where's the best place people can go and get information? Can they call their assessor's office, or should they go consult an outside tax expert? You know, what's the best way for people to maybe get questions answered on this?
I think that the first course of action should be call the assessor's office. Generally, they will have someone who's become knowledgeable with the provisions of Prop 19 and is able to answer the basic questions. I think a lot of assessors prefer that you can initiate that with a phone call, but follow it up with an email. Post your questions in writing, get a response from the assessor. I think the assessors are still in the process of educating themselves. I know the California Assessors Association is working with both the State Board of Equalization and the state legislature to try and iron out what needs to be resolved, either through guidance from the Board of Equalization or through legislation initiated at the state legislature. But start with the assessor, ask those questions. I think it's the really critical point to get out right away. It has to do with family estate planning. If you are a property owner that has property that you're planning to pass on to your children, and it involves more than just a principal residence, you should be talking to your assessor now, because February 15th is going to be here pretty quick. It's roughly 2 months away. Yeah. And
exactly.
So kind of caught everybody by surprise, but place to start is with your local assessor.
All right. Well, thank you again, Karl. This was very enlightening, and hopefully will help some of our taxpayers out. So thanks so much for your time today. And for those watching online, we'll keep this video up until February, so you can refer back to it if you have questions. And click that link in the description for more information, and we'll be sure to share any more details as we get them. So for now, thanks everybody.
Well, and Andy, just one more thing, you can add my contact.
Yeah.
You can put my contact information down below.
Absolutely. All right. Thanks everybody.